Pretty loud. Okay. So first presentation will just be me and Malia, and we'll be talking about an overview of U.S. privacy laws. So I put this up here. A lot of you have seen this U.S. state privacy legislation tracker. Gets updated all the time, and a lot of us watch it almost every week. We'd like to see what's going on. We're out of legislative session, so we're not watching it as frequently. But the key here is that you see these states in red. This is what we'll be focusing almost all of our attention on today. These are states that you are either familiar with their privacy laws already, because California gets their update, as many of you know, starting on January 1st, 2023, and also coming into effect in 2023, Utah, Colorado, Virginia, and Connecticut. So we're basically going to be focusing on these states. And we'll talk about the timeline of them coming in, the scope of those laws, the exceptions, some basic requirements, and then some activity-based requirements. So let's focus on the timeline first. Oh, excuse me. So I'm sorry, there's a lot on this slide. But if you're to map this out, you know, a lot of, like I said, all these laws come into effect in 2023. And we start with California gets their update. It's called the CPRA, but following that date, it's just the CCPA. You'll notice we'll refer to both the CPRA and the CCPA synonymously at times. Know that if we ever say CCPA, we may be talking about the update, like CCPA as updated by the CPRA. Sorry, it's gonna be alphabet soup. I know, I even put like the alphabet soup key here on the top left because there's a lot. And on that same date, the Virginia law comes into effect. Interestingly, Virginia's law comes into effect, but with California coming into effect, but the enforcement date for California is not till July 1st. Virginia is immediately enforceable. So what you find is that a lot of states are targeting this January 1st, or sorry, a lot of compliance measures are targeting January 1st, 2023. And also important to note, and really we'll talk about this a little more, the exception for employee data and B2B data expires on January 1st, 2023. You then have Colorado and Connecticut coming into force on July 1st, 2023, and then Utah at the end of the year, July 31st, 2023. Simple enough, right? But not so much. And you know, we get a lot of questions. Why is this so complex? And part of it is that, you know, if you're looking to build out a compliance program, many of our clients, they don't want to come to us every 6 months for new measures. They want to look at all of these and do one update that could account for all of these laws. That's one reason for the complexities. You really have to look at them all, and you're kind of looking at that July 1st, 2023 date. It's going to feel a lot like GDPR when it came into effect, or when CCPA came into effect, like a big privacy push. The other reason for the complexity and why there's so much hype is because along with these laws, which we know what they are, and basically they are fixed at this point. There are some amendments that, you know, they could happen, but they're largely fixed. But they also carry regulations, and the regulations carry the same weight as the law. And as you can see at the bottom of this timeline, those regulations are still yet to be published. And that might be surprising for you when you initially read this law, because at least in California, they should have been published back at July 1st, 2023. But if you know California, which I'm getting some head nods in the room, I know you do, they're delayed, not surprisingly. We now anticipate that probably end of the year is our best guess, looking at the timeline that happened with the initial CCPA regulations, when they'll be published, and then they'll be finalized probably for the first half of next year. Also, Colorado has its own regulations that are yet to be published. So that's why there's so much hype, so much uncertainty. But we're really focusing on that July 1st date, as I'm sure many of you are. Now, when we talk, let's actually just pause here for a second. A common request we get from GCs, I have this conversation all the time, is what they are looking for, and what you may be looking for is, give me the net. Read these laws together and give me one provision instead of 5 provisions that have different requirements. I'm getting some head nods. And so they want us to look at the net. And I want to stop here because what you're going to get from here on out is basically a lot of comparisons. You're going to get comparisons across these laws. We're going to try to focus on practical guidance with regard to those laws. But if there's a lot of information on the slide, apologies in advance. It's because we're trying to compare all of them together so we can give you kind of the net effect of all of these laws within concepts. So first, let's talk about scope. This may be one of the most important slides in the presentation, in that some of you, as I know, I have this conversation all the time, are how maybe I'm not in scope. That might be nice. Maybe I can just attend this first presentation and then just wait for happy hour or come back to the happy hour. So this is going to be an important one. Now, there's similarities across these. First, note that only California and Utah have a revenue threshold. And revenue thresholds are unique in the US, like in the GDPR, there's no revenue threshold. But in California, you have a revenue threshold. In Utah, you have a revenue threshold. Although in Utah, it's a revenue threshold plus. So in California, CPRA, you get just a revenue threshold, and then any amount of this processing. With regard to the Utah, it's going to be revenue plus the processing of data. And specifically, what you see once you get to this kind of the processing volume prong is you get each of these states will move to 100,000 consumers. So it's consumers where the revenue threshold is global revenue. The consumers is the consumers of that state. They've defined in each of these laws the consumers of that state. So when we're in California and you're looking at that volume of processing, it's 100,000 Californians. When you're in Utah, it's 100,000 Utahns. Utahns. Gosh, Utahns. Oh, sorry. I love saying this. Like, I know Connecticut is Connecticuters, I think, unless there's anyone that wants to correct me on that. But it's really, yeah, Colorado, that's so boring. So yeah, but you're getting 100,000, and as you'll probably know if you're familiar with the CCPA, it's 50,000. That number moves up to 100,000, and that is local residents. Now you also have a sale prong. These are all 4 prongs for scoping into the law. And basically the uniqueness there is where if you are engaged in sales of data, and we'll talk about what that means, and that makes up some portion of your revenue, then you could also be within the scope of the law. And then we'll talk about the obligations for that. One thing I will point out is Colorado has a very interesting sale prong in that if you're doing how it's written, so this is the middle bucket here, if you're doing any amount of sales and you're collecting the data of 25,000 Coloradans, not 100,000, then you would be within the scope of Colorado's law. So that's a unique aspect of that prong. Now, what does this mean? Obviously these states are not created equally. So it's really interesting when you look at that middle prong, that volume of processing threshold. And I just did some numbers before this. California, 100,000 Californians is 0.0025% of their population. 0.0025, very low. Virginia is 0.012. Colorado is 0.018% of the population. Connecticut 0.028. Utah 0.032. But talking about that interesting sale prong in Colorado, 25,000 Coloradans, that's only 0.0044% of the population. So, but I guess the point here is that there's complexity, and also that's a low number. I mean, if you have any business in California, and I'll talk about definitions of personal information, but any business in California, 0.0025% of the population. And so when you're looking at your footprint, or 0.0044 of Colorado, because we're sitting here in Colorado, that's a small percentage of the population for your business activities. I will point out, here's the definition of personal information or personal data between these laws. Largely, they are the same. We don't need to really spend any time on it. It is a broad definition of personal data. It's any information that relates to identify an individual, essentially. Very broad. They're largely similar. These are what make these laws general privacy laws. Name, address, all those things count. Cookies, any types of profiling that you're creating, all of that counts as personal data. Super broad. I will mention that we also, with these laws in the US, we get definitions of sensitive personal data. Now, if you've already worked on your GDPR push, you know what sensitive personal data is, right? You know what these elements are. In the US, we don't really have this. We have sectorial laws with regard to certain industries, like COPPA that may apply to children's data, so it's presumptively sensitive, but largely we don't have this concept in US laws. But we do get it once we get into CPRA, broad definition of sensitive personal information, Virginia, Colorado, Connecticut, and Utah. And we'll talk about what this means. I know this is micro skip for you, but what you can see very clearly is that California has many more elements, even than the GDPR, even far more than GDPR. And Virginia, at the bottom here of the slide, you'd see Virginia, Colorado, and Connecticut also have broader elements, and Utah, broader elements than the GDPR. So we're really look at these and think we're getting more detailed requirements than even the GDPR with regard to collection, processing of sensitive personal data. And we'll revisit this again once we get to the requirements. What do we have to do with regard? We are collecting these elements, especially with regard to employee data. Now, if you don't mind, we might save questions just because of the webinar till the end. I should have said that at the beginning. If you don't mind, we'll do questions at the end. And so why don't we talk about the exceptions now?
Yeah, so equally important, Chris just covered the fact that these are comprehensive consumer privacy laws. Really broad strokes with what's included within personal data or personal information, but there are a lot of exceptions. So we're going to go through some of those exemptions or exceptions. Oh, sorry.
You want me to do it?
That's okay. So these first few ones we'll go through are kind of just in terms of the data level. And it's really just an incentive to start to take, for businesses or controllers of the data, to take data protection or data minimization measures to then exempt that data from the scope of some of these privacy laws. So this first example here is explicitly excluded in California and Utah. So if you're using the data in an aggregate form, so compiling the data, presenting it in a summarized form, that data is going to be exempt from explicitly California and Utah, but also inherently exempt from what the definition of personal data is, which is reasonably linkable to an individual. So in this instance, it's not. This is distinct from, these are all going to be nuanced key terms, but might be relevant to some of the businesses. But de-identified data, in this instance, you've removed enough of the information such that there's a reasonable basis or justifiable confidence that it cannot be used to identify an individual. So there's some obligations surrounding the use of this type of data because it's not aggregated or anonymous. Here you have to take reasonable measures to ensure that it remains de-identified, make a commitment that you're going to only use the data in de-identified form. And if you have any downstream partners that you're sharing this data with, vendors, service providers, you have to contractually obligate them to maintain these same or agree to these same restrictions. And this is across all 5 states. So pseudonymous data is a limited exception. And again, just a way of incentivizing businesses to take these extra protections to get some small carve-outs from compliance with these laws. So pseudonymous data is across all states except for California. And essentially, you do not need to comply with some of the traditional consumer rights to access the data, correct data portability, deletion, if you're pseudonymizing the data, meaning you're replacing an identifying or an identifiable information element with a pseudonym. So hashed emails or taking an email address and replacing it with some random numerical number.
Right. Commonly, encryption is what you might think is
there's a key to link these. Right. Link it to an individual essentially. And so that's why it's still going to be under the scope of these laws, but there will be some benefits to taking these data protection steps. And then obviously putting in security measures around this data to ensure that it's secure and that the data isn't being linked. And similar to the de-identified data, you are going to have contractual obligations to downstream partners for processing this type of data. Publicly available information. So this is currently under California, but expanding in 2023. And this again is going to be across all 5 states. And this is a full exemption. So this is a business-friendly addition. So it's not just your government records, information in government records, but also it's going to include information that the consumer themselves or through another person have made available to the general public. And the basis is going to be from the business's perspective. So if you're doing your data mapping or relying on this, if it's recruitment agencies, for example, what's on LinkedIn, what are they putting on Facebook? Can you point to those sources as how you collected that information and then be able to rely on this exemption? So this is just going over those same data level exemptions we just reviewed. And then the last two there, all the new states, Virginia, Colorado, Connecticut, Utah, have permanent exemptions for employee data and data collected in that commercial context, the B2B business-to-business data. California is currently has limited exemptions for those type of data. Obviously, these are all consumer-facing, drafted with that in mind. But beginning on January 1st of next year, employee data, B2B data is going to be subject to all CCPA obligations. This is a really big shift. If you're B2B, you were probably kind of skirting under California because the risk was a little bit lower, not dealing with consumers. Employee data, it's going to get probably complicated. So these are your job applicants, independent contractors. From a B2B context, think of suppliers, resellers, just customers visiting your website. And there's the look back period for California. So any data you've collected this year is going to be subject to consumer requests. You need to be providing expanded privacy policies to these buckets of individuals. And then particularly with your employee data, understanding, especially if that's a lot of sensitive information, understanding who that data is going to, vendors, other service providers, and ensuring that you're getting data processing agreements in place with them. And the sad news is, particularly for the employee context, we have less than 4 months before that goes into effect. And also January 1, there is a current right to cure. AG gives you notice. You have 30 days to remedy that before any sort of action is taken. And that sunsets January 1st. So not only are they adding this whole new bucket of data, but there's not going to be time to cure if you're notified of a violation.
With basically with no guidance from the California AG or the CPPA, which is the enforcement body starting on January 1st. Or, well, when it's enforced.
Right. So as Chris mentioned, both Colorado and California are going through regulatory processes right now. California has issued an initial draft of proposed regulations to go into effect come July. Problem is they haven't addressed this new group of data with employees. There was a bill that was presented in the California legislature to extend these exemptions. The California legislature closed at the end of August without passing it. So
like guidance that would be very useful. Like if an employee wants to make a request to delete their bad performance review, how would you respond to that? Under what exceptions could you keep the data or not provide, not delete it?
And then just one last view of these exemptions. So there's both data level exemptions as well as entity level exemptions. Obviously, this is a detailed slide, but something that you can refer to see if any of these are applicable, particularly in the employee context. There's some entity level exemptions, such as if you're a financial institution subject to GLBA, you're a higher education institution. Some of these might come into play. If you've been operating under California, you know that it's been a little more complicated because outside of nonprofits, everything is a data level exemption. So you're a financial institution, someone visits your site, that data shouldn't be subject to GLBA, but maybe once they start to fill in your pre-qualification form, then it's triggered. So these new laws at least provide some of those more entity level exemptions, but something to really look back to here.
Before we start into the basic requirements, let me also just read off. We're going to have a applying for CLE in some other states, and they require that you read off a code in the middle of the presentation. So for those people applying for those CLEs, the code is privacy, capital privacy 2023, and you can send that by email to swilliams@kofirm.com to register for that CLE. That's just for our non-state, our non-Colorado CLE participants.
Okay, So assuming you fall within the scope, and we'll kind of address this, assuming you're applying or subject to all of these state laws, what are some of the changes, particularly as it concerns if you were operating under California's CCPA? What's 2023 going to bring? And so some of the new requirements are data minimization measures. You're going to have your standard transparency obligations, such as privacy policies. There's going to be new and expanded consumer rights. There's going to be a requirement to implement reasonable security measures for the data, and then ultimately getting contracts in place to the extent you are transferring or processing personal data. So the first one, and this will generally be high level, knowing that some of our subsequent sessions are going to go into detail on some of these topics, but basically there's a requirement that now that your collection and use and the retention of data has to be reasonably necessary and proportionate. And it's worded in so many different ways, but required across all 5 states, with the exception of Utah. As you'll find, Utah, end of December, doesn't matter, business friendly, comply with the other state laws, because they're the ones that are going to impose some stricter requirements. And interestingly, as I said before, California has published its initial set of draft regulations, and this, what's reasonably necessary and proportionate, currently is going to be what an average consumer would consider reasonable. So something to keep in mind. California will always be the outlier here, but they're going to require that you disclose your retention periods for each type of category of personal information that you're collecting in your privacy policy, and that's disclosed at or before the point of collection. So updating, to the extent you have them, your data retention policies, maybe getting rid of data that you don't need before this goes into effect next year, and updating your privacy policies to provide those disclosures to consumers. This is also, again, important in the employee context, B2B context.
Right. I mean, one thing that's kind of interesting here, you're going to hear this, is like Melina said, Utah is like exception land, like a ton of exceptions,
Right.
very business friendly. Right. I would say California is maybe the most strict on most requirements. There's a few outliers with Virginia, Colorado, and Connecticut, but you'll find that. And I mean, I guess the bad thing is that California is the first to come into effect. Utah's the last. So, but you'll see that. I mean, look
Yeah.
to, if you
And
are.
California has an agency, so they've got people
Right.
dedicated to interpreting this law. So whether you're just subject to some of these other laws, really keeping an eye on the regulatory process in California is going to be important.
Yeah, if you hear that in our alphabet soup, that's the CPPA, and it will be the first government agency in the US dedicated solely to privacy. So it'd be really interesting to see, like, we follow
Yep.
that. Good.
Okay.
Oh, sorry guys, having a technical difficulties.
Ryan.
Yeah, Ryan, we might need you.
Well, I'll just continue on. So the next one is going to be your notice requirements. So we're familiar with, obviously, the privacy. All right,
Right.
all right.
Ryan to the rescue.
Easy.
Thank you, Ryan.
Okay. Is it working?
Let's see if we have to click in.
Okay.
Right.
Okay, so we're all familiar, you're gonna have your privacy policies. California currently requires some additional disclosures. There's a short form privacy policy for employees, which will now be an expanded privacy policy come first of next year. They also have this just-in-time notice requirement. So whether you're a brick and mortar store or you're online, you need to be providing notice of what data is going to be collected, how it's going to be used, who you're going to share it with, whether you're selling data. So just knowing that those are going to be expanded. There's also going to be particular activity-based requirements if you're processing sensitive data or selling data, for example. There'll be some additional disclosures there. So what are the additions going to be to your privacy policy? Obviously, data collection, use, sharing. California has its own requirements to be listing the type of sources from which you're getting the data. They're also going to require the data retention periods that we discussed. And unique to California is they have a 12-month look back period in terms of these disclosures. None of the other laws have a similar look back period. And then there's going to be additional disclosures surrounding sensitive data, and then those other activity-based processing, selling, sharing, and a new concept of an appeal process for consumer rights for some of the states. So new and expanded rights, we will now have a right to access. So if you're already operating under California, you have the right to know certain details about the processing of your own information. You have the right to access that information, get a copy of it, which you can then send to another third party. The right to delete the information. So this new right is really just kind of falling in line with GDPR, the right to act or to correct that information. And then there's going to be kind of teased out and expanded rights concerning sensitive data and selling and using data.
If you're just familiar with the GDPR, I mean, this largely, so like the selling and using data for behavior-based advertising could be analogous to the right to restrict processing, but it's not as detailed. It's in the GDPR, it's far more detailed in California.
Right. And then the requirement to implement reasonable security measures. So again, these are comprehensive consumer privacy laws, but we've kind of gone through some of the exemptions and exceptions. So maybe it's not going to pull in as much data here as you think. That said, states do have data breach notification laws. There's other freestanding or sectoral laws that are requiring security measures be in place. But that is an explicit requirement across the board for these states. So drafting and having a written information security policy is the action item there. And then contractual requirements. All of the state laws are going to require that if you're using a processor, vendor, service provider to process personal data, store personal data, you need to have a contract in place with them with certain provisions. California requires that even if you're acting independently, controllers, other businesses selling that data, you also will need a contract with any third party. So really expanding the contractual requirements for California particularly. All right.
Great. So yeah, let's take stock. So let's say now you're already through the scope exceptions, or the scoping aspect. Maybe you've been able to say, okay, this part of my business maybe is exempted, or this part of data that I'm getting, maybe it's publicly available source. I can exempt this data, but there's still some in the scope. You have what Malia talked about. All those are required then. Once you're in scope, those are required activities, those 5. But it's not that easy. There are additional requirements, activity-based requirements. And so what I mean by that is these are requirements only if you are engaging in a certain type of activity. So if you're selling data or you're engaging in targeted advertising, there's additional requirements. We'll talk about those. If you're not selling data, you don't have to put in place these requirements. So let's talk about those. These are kind of the top 5, these additional requirements. So the sale, you've already heard us say sale a lot, and we're going to talk about it more, and you're going to hear it quite a bit. That definition, and I know some have wrestled with this definition quite a bit, but we're gonna dive in just a little bit now. The law, all of these laws have definitions of sale. Now you can see between these laws, some of them have what we traditionally think of as a sale for monetary consideration, like a data license, maybe a referral agreement, where you're giving someone a lead for a referral fee. That's a traditional monetary exchange of value. Other definitions here have other valuable consideration. What the heck does that mean, right? What does other valuable consideration mean? And when the CCPA had the similar definition, almost the same with the other valuable consideration before the CPRA, and we have a little bit of guidance. We'll talk about that, but there was a lot of companies at first that said engaging in behavioral-based advertising, that's not a sale. Or entering a data co-op where you contribute your customer list and maybe get an aggregate customer list from all the co-op members. You're not selling any data, but you have to provide your data to be part of the co-op. Is analytics providers engaging with an analytics cookie provider, is that a sale? And there's been all different types of interpretations. What has been clear is at least the California AG has clearly come out and said, all you companies that think those are not sales, you're wrong. That's a sale. And most recently, they came out with the Sephora enforcement decision. This is the first decision from the enforcement decision under the CCPA, regulatory enforcement. And so the AG tells us clearly, and I'm just going to read here, I hope you don't mind, that Sephora's decision to provide third parties, including advertising networks, business partners, and data analytics providers with access to its customers' data in exchange for services from those entities was a sale of personal information. This section that you see quoted here is broadly defined sales as the exchange of personal information for anything of value. Sephora's relationship with these third parties met that definition because Sephora gave companies access to consumers' personal information in exchange for free or discounted analytics and advertising benefits. I mean, when I read that, I was floored, like analytics providers, and I've been doing this for a long time. Any discount, how would even, maybe Sephora wouldn't even know if they're getting a discount. They don't know if they're like the rack rate is a discount as part of that. So there's a lot of ambiguity here. What's very clear for the regulators of sale is not clear for everyone else. And so there's still ambiguity, but take that. I mean, you have to read that. That's why I had to read it like directly from the quote. The enforcement decision right now is this is a very broad definition. Anything of value, any type of free or discounted services that you receive can be qualified as a sale. So, and you see that, and Colorado also has this valuable consideration, and Connecticut. So California, Colorado, Connecticut. So what does that mean in practice? It means you're going to, if you engage in this activity, you have certain updates to your privacy policy to make. You also, California, have to provide an option. Do not sell my personal information. That's why you see it at the footer next to the privacy policy for so many companies. And so you see that that footer, it's going to be used a little bit differently start 2023, and I'll tell you about that right now. So California AG, when they're passing this law, they said all these companies that are saying targeted advertising is not a sale, hold my beer. We're going to make it even harder. So they come up with, and if the other states follow suit, is that not only do we think it's a sale, but I know you don't think so, but is that we're going to state explicitly in these laws that now we're going to come up with a new, very complex or convoluted definition of sharing. And I put the definition of sharing because it's almost unbelievable. No one would think like if I share data that I'm engaging in cross-context behavioral advertising. But if you're in California, that's what it means. Sharing. The other states luckily have more clear definitions of targeted advertising. But essentially what happens is that link at the bottom, do not sell my information. Now you have to have another link that says, do not share my information. And if you're engaging in sales and sharing targeted advertising, you can combine those links, but still there's multiple options now. It's going to make working with your consent management platform extra important. But so now you have, now you have this convoluted situation of analytics providers being a sale, behavioral-based advertising providers being targeted advertising or sharing, and we move down in the complexity chain. So we get a lot of questions on that too. So I'm guessing there might be some questions here in the end from our ad tech folks. Profiling and automatic decision making. You're going to get some confusing definitions. What is profiling? And you're also going to have to know what are legally insignificant effects. So these states, and I put them at the top, you have the four, California, Virginia, Colorado, and Connecticut. Those four states have options to opt out of profiling if that profiling is producing decisions that create legal effects. So what does that mean? You can see profiling is very broad. Any type of automated processing for basically anything, any kind of personal preferences, interests. Very broad definition of profiling. A lot of times you'll hear from, you see like headlines, profiling not allowed or opt out of profiling. That's not what they're saying. They're opt out of profiling that is producing these legal effects. So what do legal effects mean? Legal effects are this, if anything, your analog here, if you're not familiar with GDPR, has some concepts of legal effects, but they don't define them. This is where you look at FCRA and you look at what are some of those more sensitive type processing, like using profiling, automated decision making for the purposes of qualifying someone for financial services. So banking services, housing, insurance, think FCRA. Education enrollment is different.
criminal justice, employment, that's FICRA, healthcare services, and access to basic necessities like food and water. All of those, so broader activities than what we think of for FICRA or any clear guidance from in GDPR from the Working Party or the European Data Protection Board. So you have very specific activities that if you are using automated processing for any of these activities, you have to give an opt-out right. And you also have to provide how you make that update in your privacy policy. So the functional guidance is you need to update your privacy policy if you are engaging in this activity. We're back to sensitive personal data. So if you're not collecting any sensitive personal data, good news, you don't have to have any of these requirements. Problem is, now with the employee exception, we're all collecting sensitive personal data, all businesses. W-2, you have social security number, that's sensitive personal data. You know, any kind of driver's license number, date of birth, that could be sensitive personal data. So you're thinking, what are these sensitive data elements? And so you likely have them. Now there's a split. California and Utah are notice and opt out for certain types of uses. Virginia, Colorado, Connecticut are opt in. So, and I put California is probably the most detailed. Specifically, the exception there, which is very important, is if you're using the data for a purpose that is expected by the consumer. That means, you know, if I'm using W-2 information, sensitive information, like I talked about, only for that purpose, you're not using it for some extraneous purpose, you should be fine. You're an exception. Then it's just notice, not the option to opt out. So these are, you know, basically what we've had to start doing is taking stock of all of the, basically doing a data inventory for all of our clients' sensitive personal information, because there's these additional requirements, either opt out, opt in, notice requirements. And then also in California, the opt out is through a special link called limit the use of my sensitive personal information. You can see the footer is just getting very long and annoying. You know, obviously the point of these laws. But I'll also point this out, you know, again, not all of these definitions are created equally. This is why, you know, even though Virginia, Colorado, Connecticut are opt-in, likely a lower effect than California here, with such a broad definition, such a broader than the GDPR, very broad definition for sensitive data. So even though it is notice and with some exceptions, and then opt out, limit the use of my sensitive data, still, I mean, with this broader set, you're starting from a bigger pie, it's going to be a compliance burden. And then data processing assessments. So if you're engaging in certain activities, you have to do a data protection assessment. This will largely look, if you're familiar with GDPR, it's going to look like a DPIA, a data protection impact assessment. It might look like a legitimate interest assessment. We don't fully know yet, but there is some nods in these laws to other jurisdictions having these requirements in place, but they're only for certain type of activities. Activities you may be now familiar with, like targeted advertising, sale of data, profiling that creates legal effects largely, and sensitive data processing. Also, data activities that have a heightened risk of harm. We don't have a ton of guidance here on this, but likely it's going to be something like collecting information from children to the extent that's not sensitive data under the law. Other types of, you know, geolocation, biometrics, higher, very sensitive data or sensitive activities with regard to that data. And so here you're going to need to produce, the functional policy is a data protection assessment. Like I said, data protection impact assessment, you know, and have those ready in case a regulator comes knocking. Some of these laws do require that you have them ready and that you produce them within a certain time period, a short time period. And so those have to be produced upfront, not when requested.
Yeah, and we did get a couple of questions, but we can open it to the room too with first if there were any questions. Yep, go ahead. So do we?
Yeah.
So let me know if I have your question right, but for purposes of the webinar folks, your question, is it possible with targeted advertising to put the power in the hands of the consumers? that generally the question?
Yes, especially if you put it in the approach, you could just opt out as specific types of ads themselves. So fine, it's only data that we want to put. I speak to these ads.
I mean, you get a GPC and like, yeah.
Yeah, I would argue that it's really in the hands of consumers. Actually, the burden is still on consumers to exercise those rights. So unlike GDPR or some other frameworks where you can't drop cookies until you get consent, here it really is an opt-out model. So it is on a consumer's burden to implement those controls. And so California already, for the California Attorney General, requires the global privacy control to be treated as a request to opt out of sales, targeted advertising or sharing, as Chris was saying.
Yeah, and also, I mean, that's why you've seen even in the US, companies that don't have GDPR exposure, they've started to implement consent management platforms. There's the banners, not the like the cookie banner that says you accept all cookies, but the banner that will say manage my choices, and then you'll have access to certain categories of cookies like functional analytics, target advertising, micro social media, various categories, and then you turn them on and off. Those are largely geolocated to certain locations. We don't have these rights in Colorado today. So if you're logging in from Colorado, you might not see that banner, but largely these companies might geolocate them to Europe or California, and they might be defaulting them to certain choices. So they're giving you choice, and they're also making certain selections geolocated to basically their legal exposure to these laws.
So in terms of the business's obligation, it's to ensure that you have these mechanisms set up so that you respond to those signals, if you will, or browser controls to be able to not send targeted advertising to those consumers. Doesn't mean they're not going to get ads, which I think is the real catch.
Yeah.
But just might not be tailored.
So I'm struggling under the new definitions of sensitive personal information as it relates to audience segmentation in the advertising industry.
Right.
Because segments can get fairly granular. It's kind of obvious, right? You're talking about a cancer diagnosis, that's definitely going to be sensitive personal information. But what about a segment that's targeting folks who might be in the market for just cold medicine? Right. And so it's all health related segments, but very different from a sensitivity perspective. And I'm curious if you've seen anything.
Yeah, definitely. That's a great question. And this is something, thank you. Yeah, let's repeat the question. So this is basically inference. Tell me if I'm right, but basically when you have certain data, maybe you're enriching data, you're getting profiles in, and then you're using those data and creating inference. So the data itself might not be sensitive, but you're creating inferences from those data that will reveal sensitive data elements. And then you have to treat those as sensitive. And so this is something that you've seen a lot of movement in the EU recently. And there have been cases from the highest courts in the EU and some lower courts as well that say, if you can make those inferences on sensitive data, you have to treat it as sensitive data, even if it didn't come to you as sensitive data. You have to treat it as sensitive. That's the EU. You have in the US, you have from the California Attorney General, you have an inferences opinion that also will say that inference data that's sensitive, it should be treated as such. All your inferences have to be treated as personal data that may be subject to a data access request. They don't dive into the sensitive aspect of this, but I think you would take that one step further and get to the same conclusion that you have to treat those inferences that you're creating that are sensitive elements as sensitive. And you also have, what was the other one? There was a recent, you do have, this isn't from any of these states, but the FTC recent enforcement decision.
Certain products.
That's right, exactly. You saw this, the FTC came after a data broker that was selling geolocation data that revealed location to an abortion clinic, I believe it was. Sensitive data having to do like elements we've talked about. They didn't specifically tie this up as much, but you certainly have to believe one step further that the interpretation is going to be to the extent someone can make inferences from this sensitive data there. It's really interesting because that was the data provider, not the person making the inference, but they knew what people were doing with this data and they went after the data provider.
But again, you have to treat it as sensitive.
No, I completely understand all of that, so.
Oh, sorry.
thank you for setting the tone, it comes down to. If there's an audience segment, right, that's health related, is it? Like, if it's a cold medicine segment, that's health related versus, like a potential cancer diagnosis, right? And I'm picking up specifically on the definition where it says a physical condition or diagnosis. Is a runny nose a physical condition that's considered sensitive personal information through that inference process that you just described? Because it's not the same level of sensitivity, right? Whether I have cancer or I have a runny nose.
Right. I mean, I would look at how you're using that data as well. So even if it kind of skirts with the definition of the data, and we don't know, like, these laws not in effect yet with regard to sensitive data, so we don't have a lot of interpretation. But so if we're kind of like on the border, I would first look at, okay, well, what other indicia do we have that this could be a sensitive data element? And there I would look at your use of that data, so how you're using the data, and is it something that would be indicative that would bring you closer or further away from that definition? Are you using it for diagnosis to make recommendations like, hey, I want to sell these people cold medicine, or I want to sell these people cancer drugs, or whatever it is? I would look to the use and see how close it gets you to the data. Also, I would take a gut check, and a diagnosis of a cold versus a diagnosis of a certain type of cancer. We all know their gut check, the regulators are going to be looking, diagnose cancer. So
Sometimes.
we hope, yeah, well, exactly.
Data broker, I'm very familiar with that complaint, and the data broker, yes, dealt in geolocation data, but they absolutely were not making any inferences. So by, that description, who was actually causing harm at that point?
Right, exactly. And a good question. I'll repeat it. Sorry, I should repeat the last one. But yes, right. Like, we're looking at where's the harm and is the regulatory priorities where they should be. We're going to come up with different opinions. A great point, and it is something we wrestle with quite a bit. And had, gosh, I mean, with regard to the data broker that just had the enforcement decision, had our recent Supreme Court case that just came out, didn't come out that way, maybe the sensitivity would be down. It's really interesting. I mean, you see this all the time. Look at information collected from children, at certain times that is a hotter issue than others, and you will find that the regulatory priorities really shift here, and sometimes shift in illogical ways, like what I talked about. They went after not the people using the data for a certain purpose, but the data provider, the data broker, which was very interesting. And and certainly plenty of criticism has been lobbed at the FTC for that, but it came out nonetheless. Yeah, definitely. Thank you for your question. Yeah, great question.
Do we want to try to, is there any more in the room, or?
Yeah.
I have a question, and mine are probably a lot more basic than some here, but in terms of the numbers, the quantity, if you're dealing with B2B, most companies sell to fewer than if you're selling to consumers. So is that still at that 25,000 or 100,000 numbers of B2B? And then my question then probably gets into the sensitivity of the information of, well, yes, when I sell to BNSF, I know Mary Smith, who's the controller there, and I've got her email and her phone number, business, all business.
Yeah.
Is that starting my count of 25,000 or 100,000?
Yeah, this is, yeah.
And we should just clarify too, that would only apply in California. So all the other states don't need to worry about the B2B context, but.
Well,
Oh, okay.
no, this is a good point. And because, what Malia's talking about, let me repeat the question. So
Yeah.
when you're in the B2B situation, what data counts for the processing, like the record volume that we talked about, that processing trigger early on in the presentation. And so, yeah, let's hold on. California is a good point. We're gonna get to it. And the first I would think about is all these definitions are largely based to the controller processing data. So the first thing, like in California, it's just the business or the controller. You might have a lot of business. Let's say you have a SaaS company and you have 100 customers. You have 100 contacts, but through those customer agreements, you get thousands of data that you process on behalf of those 100 customers.
Yeah.
You don't count the thousands and thousands of data because you're a processor with regard to that data. You have a special relationship as a controller with regard to the 100 customer data, the business contacts. Yeah, and you also have, you count the business contact, but you may also have a website. And there's IP addresses coming in, and may also have a newsletter. It might be people signing up by email, even if they're not customers yet. You gotta count those. All your tracking, if you're doing any behavioral-based advertising, you're laying cookies in a browser, you gotta count those. Because essentially the legal term of art, and sorry for the jargon, is you are determining the purposes and means of that processing. You are deciding which customers that you market to. You are deciding if you have a newsletter and if you collect job title and email and address or whatever you want to collect. You're deciding if you want to go to an event and collect, you're designing your website. You're deciding if you want to place an advertising cookie. You are determining the purposes and means of the processing. That's your controller obligations for that account. Then you get into your processor obligations, which we'll talk about with regard to a data processing addendum. Now, Malia brings up a great point. In California, there was an exemption that will sunset on January 1st. So just for California, they have a B2B exception that has sunsetted, and that exception remains and is valid continuing on in Virginia, Colorado, Connecticut. But in California, because the B2B exception will sunset on January 1st, you have to take that into account as well.
So that's the state I need to worry about is California.
We're going to keep coming back to it.
And let me make sure I understand the context here. I have exactly what you're talking about, a SaaS client here in Colorado. But we sell to every state and all over the world. But I only care at this point about the California clients. Is that right?
Well, it's the clients, and then where is their base? You're actually worried where their customers are. It goes down to the consumer level.
Oh,
Because the client is going to be, they might be based here in Colorado or wherever they are. They might be, in Florida, but they target specifically consumers in California and everywhere else maybe. But let's say they have the specialty, they have a branch in California, a branch in Colorado. You look at the base of records from consumers in these states that we're talking about.
And maybe we'll move it offline just to move on to the next presentation. And,
Oh, yeah. That's good. And yeah, there will be more time for
Yeah.
questions, as you can see here.
and
We are,
diving into some of these topics.
yeah, we're gonna dive in. And sorry if we didn't get your question. We'll get to it next question session.